Hello and welcome to Legal Bites. If you're new here, my name is Alita. I'm a lawyer licensed in California and DC, and on this channel, we explain the law one bite at a time. We don't give legal advice, but we do talk about how the law works and try to look into our crystal ball to see how things might turn out. If you're enjoying this on YouTube, we'd love it if you could like the video, subscribe to the channel, share it with friends, all the great YouTube-y stuff. And if you want to listen while out and about, we're now offering our live streams in podcast form where you can leave a rating and review. Links are in the description below, as well as to our clips channel where you can find some of the best clips taken from our live streams. Otherwise, if you want to catch me elsewhere, you can find me on Twitter, Instagram, and Facebook. And if you want to support the channel, you can do so on Locals, Patreon, or by becoming a YouTube member, or by buying some really awesome Legal Bites merch. Again, all links are in the description below. And with that said, let's get into it. Hello. Happy Friday. Good morning, good afternoon, good evening. Wherever you are in the world, I hope you're having a great day and a great Friday. I hope it's been a good week for you. And we're all looking forward to the weekend, right? So, I know normally I've got live streams on Tuesdays, Thursdays, but I decided to do another one today because, well, we've got a lot of trials to be updated on. And so I figure doing a daily update is probably a good idea. So initially I was intending to talk about just Kevin Spacey, Danny Masterson, Harvey Weinstein, since that's what we're doing here, largely on this channel. But I've had so many people that were asking about the Daryl Brooks trial. So I wanted to talk about a little bit. I'm not going to be able to obviously live stream the whole thing, but and part of it is because I am at noon East Coast time. So in a couple hours, I'm going to be on Eric Hunley's channel. So I wanted to do a little bit, just get a little bit of conversation on this because it's a fascinating case, right? It's a very fascinating case. So before I do, let's say hi to everybody in the chat. So first we've got Arto Rissanen in Finland. Hello. Pamela C. Happy Friday from Arizona. Carrie Ann, hi from Ontario. Hi, Carrie Ann. We've got, I see Mary Malarkey from Chicago. I've got Cole Reeves. Good morning. Happy Friday. I've got Tish Norman. Hi, Alita. Hello. Happy to see you. It's just me, Tams. Evening from Australia. I love it. B19. Hello from Alabama's Gulf Coast. Has 01 from Alberta, Canada. Rip Gear from Delray Beach, Florida. Love it. I love seeing all you guys. Anna Costello, Scranton, Pennsylvania. We've got Krista Smith from France, I believe. If I've got the flag right, I think I've got the flag right. Ottilie Bell from Sweden. Love it. Jarl of SWAT or Jarl of SWAT from Toronto, Ontario. Love it. Secret Mix Girl, of course you're here. You are, of course, our super mod. And shout out to all the mods in the chat. I see you, Shireen. I see you too. Thanks so much for being here and for helping out and making sure that everything is super, super smooth in this chat today. Wind, hey, from the Netherlands. Caitlin Klein from Minnesota. You woke up to snow this morning? That's, oh my gosh. I'm a little bit jealous, but a little bit not, because I feel like that's a little early for snow for me, but I do like the change of seasons. I'm not going to lie. Kelly Marie from Madison, Wisconsin. Marie Garand. No, oh my God, I'm so butchering this. Mr. Bites is going to be so mad. He speaks French. He speaks wonderful French. From France. Bonjour. Andrew Young from Edmonton. Oh, I love it. On the ground from Spain. All right. Oh, and Princess Candlewax from Plymouth, Massachusetts. Mike Gilston from Boston. All right. Happy Friday to everybody. Love it. I love seeing all of you guys. Now, one of the things that I do want to talk about before I get into these details further about these cases is I am going to start on Mondays. I'm going to add a new series to the channel. And I'm excited about it because it's going to be I think it's going to be interesting. I think some folks are going to be interested about it. Now, I'm not going to tell you what it is yet, but I will say that the first people that will know about it are Bite Club members, folks that are YouTube members, local supporters, Patreon supporters. So all of those folks are going to be the first to know this weekend what it is that I'm going to be doing on Mondays. It's going to be, like I said, it's going to be fun. It's going to be fun. That's all I'll say about it. That's all I'll say about it. So, all right. Now, let's get into these cases here. The first one that I want to talk about is Harvey Weinstein. I considered maybe not putting him in the title, maybe not putting him on the thumbnail, because the news about Harvey Weinstein is there is no news about Harvey Weinstein. Trial, I mean, he's in trial, yes, but it seems like the reporting is pretty limited on what's going on there in that trial.
Marie Goron.
Oh, say it again.
Goron.
Goron. Okay, thank you. You see what I have to live with? My apologies, Marie. I will try to do better. Yeah, I have made many promises that I would learn French to some family members, and I still have not. But at some point I will. At some point I will. Oh, Nate the lawyer's in the chat. Hey, Nate. Good to see you, man. Okay, so Harvey Weinstein, like I said, the news is that there really is no news. They are picking a jury, they're doing pretrial motions. So it just seems like that one is going to be the one that just really kind of takes its time and goes through. So we're gonna do it. But I figured I might as well touch on it just to say, no news is good news, no news is bad news. I don't know. It's just there's nothing is no news. But Shireen says, I love when she talks to Mr. Bites. I always think she's looking up and talking to God. I know, it's because he's a tall guy. I mean, he's a tall guy and he comes up and the camera's right here. So it's like it's I'm looking way above the camera when he comes in. So yeah. And Nate, I'm glad you're feeling better. I'm sorry that you lost your voice. I know you live for being on YouTube. So I'm sorry that you can't be out there, but hopefully it comes back sooner than later so you can come back and do what you love. So anyway, so that's it for Harvey Weinstein. I think that I will talk about, let's do Daryl Brooks next, because that's kind of fun, because I haven't talked about it. Folks know about it. If you guys don't know about Daryl Brooks, this is the Waukesha. This is the Waukesha like car parade guy. He drove a car into a parade in Waukesha. It was absolutely devastating. In Wisconsin, and people were there, of course, for Christmas and all this kind of stuff. And it's for that to happen any time of the year is obviously horrific. Like there's no good time for something like that to happen. But it just feels like it's extra sad when it happens around the holidays, when people are, like maybe not most people. I mean, some people get very stressed out around the holidays. A lot of people do, but there's something about the holidays that it's like, it's supposed to be a time to be to be uplifted and to get in season. And it can be a very fun time. And so it's kind of extra tragic what happened, because it was like the circumstances around that event. But obviously, nonetheless, it would be tragic no matter what, based on what happened. But the thing that has been attracting a lot of attention about this trial is that it turns out he is what many call a sovereign citizen. He is someone that claims that the government does not have any jurisdiction over him, essentially. Like, this is, I'm basically like generically describing it without getting into detailed specifics. But his whole premise is, it seems like throughout this entire trial, he's trying to challenge, even just he's trying to fight a different fight than him being convicted, because it seems like what he's basically arguing is, you can't possibly convict me of murder because of the fact that you can't convict me of anything because you have no power over me because I am sovereign. So he has also decided to take the step of representing himself, which means he does not have an attorney that is making these very novel arguments, but he's making them himself, which means he is, one could say, making a lot of missteps in the courtroom. He's speaking out of turn. He's been kicked out by the judge a number of times, put into a different room so that she could mute him because he kept interrupting the proceedings. She's had to send the jury out. She's had to essentially yell at him in front of the jury because he was speaking out of turn in front of the jury. There are all kinds of things that are problematic here. And this is, I mean, it's honestly, I feel terribly for this judge because this is a nightmare case, because even though it is clear that he is sinking his case, she has to be very careful to make sure that if and when he does file an appeal, because this seems to be someone who will argue and argue and argue no matter what. And when he's in prison, I would anticipate the Wisconsin Attorney General's office is some poor lawyer there is probably going to end up forming a relationship with him. That's not, when I say relationship, I mean like they're going to be getting phone calls from him because he's going to be suing from prison when he's ultimately convicted, probably. I'm predicting this because, assuming that no one, that there's no determination that he is incompetent for this, because he's done enough things that are crazy sounding, crazy seeming, crazy looking, that would suggest that or that would at least call into question for a lot of people whether this individual is even competent enough to stand for trial, because he's doing things that are so incredibly strange and out there. So the judge is having to maintain a very tight record and making sure that every step of the way he has had opportunity after opportunity after opportunity, and that everything, that his rights are maintained. And this is one of those things that is so difficult for judges in this kind of a role when you have a pro se party, someone who is representing themselves, especially one who is not like a lawyer representing themselves. Which, of course, there's still the saying that the lawyer that represents himself has a fool for a client. And this, I think that most people would agree that seems to be true in this case. Now, that's basically the gist of this, if you're not familiar. So I wanted to, let's see. This is a little bit like a couple days old, like day before yesterday. But what I wanted to start with is this clip right here, where he is challenging the government to face his accuser. Okay. Have you guys seen this? Have you guys seen this? It's pretty interesting. And we'll go through it because I want to sort of bring in like what it seems like he's trying to do and what would normally be done. All right, let's do it.
Mr. Brooks, I'm reviewing this for completeness, and you have simply put on here, state of Wisconsin plaintiff. That's an entity. You have to name a person, sir.
So the form that she's referring to is a form that he has to submit so that he can call a particular witness. And it seems he has called the state of Wisconsin as a witness.
Well, the date we would fill in. So I'll have it shown to the state, and they can let me know their position on that.
Any legal basis why that would not be accepted, Your Honor?
You have to have a person named, sir, so that they can come and testify. You only have an entity named.
Is it not true that under the Sixth Amendment, I have the right to face my accuser?
Mr. Brooks, let me hear from the state.
Yes, Your Honor, I agree.
You can just see her frustration that she says. She's essentially thinking, I could respond with what I really want to say to him, but before I say something, let me let me buy myself a little bit of time and tell the prosecution to say something so that I can figure out how in the hell to handle this person who is, let's just say, off the wall.
I agree with the court's assessment. The subpoena does not state a person. The subpoena form specifically indicates that the person requesting the subpoena is to indicate the witness's name and address. Mr. Brooks has simply written the word state of Wisconsin plaintiff for the witness name. The state of Wisconsin is an entity. It's not a person. The state of Wisconsin cannot testify at these proceedings, so the subpoena should be rejected, Your Honor.
Your Honor, on the grounds that
Oh,
I came to you.
dang it. Sorry, guys. Hang on a second. Let me get through this real quick and then I'll put it back. Okay. All right. Okay. Let me get it back. Okay. Here we go.
that every document that was filed in this matter stated that the state of Wisconsin was the plaintiff, which would lead me to believe that the state of Wisconsin is who's bringing the claim against my client. How could they not be subpoenaed to testify if they're the plaintiff? And under the Sixth Amendment, I have the right to face my accuser. My accuser in this matter is the plaintiff, which is the state of Wisconsin. Attorney Opper also brought up that it didn't have an address on there. None of my subpoenas had addresses, as we went on the record, and that was stated that a lot of the paperwork that I have don't have a lot of the people's addresses on there. Those subpoenas were accepted, so I don't see the difference with this subpoena not being accepted for the reasons that Attorney Opper just stated.
Mr. Brooks, in relation to that subpoena, based upon my review for completeness, this court would note you have not named a person, you've named an entity, and the subpoena will be kept on file as part of the court record, but I'm not going to require the state of Wisconsin to testify in this case because they are an entity and you have not named a person.
Now, this deal about calling an entity, calling a person. So oftentimes when we have a corporate defendant, for example, you have to call some kind of a witness from that corporate defendant. What you do is you call someone who is it depends on which jurisdiction you're in, but usually what I'm used to hearing them as is PMK, person most knowledgeable. So in other words, you serve a subpoena on the corporation or on the business or on the or organization, whatever it is, and you send them a subpoena and say, I am requesting your person most knowledgeable who can come and testify. And so that one comes in and talks about whatever subject matter that you needed to talk about. So here, it seems like he's trying to call the entire state as a witness, which obviously functionally, like it seems like it's hard to know what is in his brain for what he thinks is going to happen. Like how does he think it's going to materialize in real life for the entire state to show up as a witness? Like just first off, that is part of this that feels very a little topsy-turvy, let's say. But beyond that, he's trying to pin this to his Sixth Amendment right to confront his accuser. And he's saying the plaintiff here is the state of Wisconsin, sure. But the Sixth Amendment right to confront your accuser is what comes with that right is being able to put on your own witnesses for your case and also being able to cross-examine the witnesses that the state puts on. So No one's quite giving him this argument, which of course, like, this is day what now of this trial? Like, the judge doesn't need to teach him this. The judge is not required to teach him. The judge is required to give him ample opportunities to represent himself. If he is making an argument that does not make sense, it's not her job to try to help him out by effectively representing him. And that is the hard line that judges in this position have to toe, right? Because they can't go so far as helping one of the parties, because then that is being biased, that's being prejudiced. But at the same time, she needs to make sure that anyone reviewing this case from an appellate level sees that she is being fair to him, and she's not just allowing the state to steamroll him with the fact that he is, with the fact that he is representing himself. So, based on everything that I've heard so far coming out of this trial, assuming that something wild doesn't happen and he's like declared incompetent and therefore can't stand trial or something like that, my guess is he's going to be convicted, because there's no way he's coming across well in front of this jury. There's no way that, I mean, he's been laughing at witnesses, and when they've talked about him making threats, there's so many things that are likely weighing in the jury's mind, that are going to be inevitably impacting them. But if and when he is convicted, I would expect this to not be his last lawsuit, right? This last judicial fight, because number one, he's probably going to try to appeal. Number two, he's probably going to file a number of lawsuits from within the correctional system, talking about all kinds of things that he's entitled to, and all kinds of, prison conditions and things like that. And there's a lot of that. I don't know how much it happens in Wisconsin, but I know that in California, it happens quite a bit. So I've been on those cases. I've worked with those kinds of cases, and they can be very frustrating. I can tell you that when you're on the other side. So I pity the attorney in the Attorney General's office in Wisconsin that I would hypothesize would end up having to hear from him on a regular basis in cases like that. So
Are they not, or are they not the plaintiff, Your Honor?
They are the plaintiff in this case, sir.
And why are they not able to testify, being that
Sir,
they?
you've named an entity, not a person. People are called to the witness stand to testify. You have had an opportunity to cross-examine every single person who has been called by the state to testify in this trial. I believe that your Sixth Amendment rights have been complied with.
Not if I'm not allowed to face my accuser, Your Honor. My accuser in this matter would be the state of Wisconsin. And with all
Sir,
due
I believe your
respect,
Sixth Amendment rights in that regard have been complied with.
I'm requesting a written judicial finding of fact and conclusion of law on this issue, for the grounds that I just stated. It was seen, based on the Sixth Amendment, that I'm not being awarded the chance to face my accuser, which I should be awarded that based on the Sixth Amendment. If I'm not able to face my accuser, then how can the claim even stand?
oh geez, again? Okay, sorry guys. Maybe it is time for me to get YouTube Premium. Normally I'm able to click through the ad beforehand and not get interrupted by it. And the reason why I usually don't, or why I haven't gotten it yet, is because I wanted to know what the ad experience was like for people that don't have it, because we're able to sort of pick where we put ads and videos oftentimes. So if things get infuriating for some ads, I like to know what the other side of that looks like. But at this point. I'm getting interrupted quite a bit.
Face my accuser, then how can the claim even stand? How can a claim be brought against my client if I'm not able to face the accuser?
So this case is a criminal case in a court of competent jurisdiction in the state of Wisconsin, Waukesha County. This case was initiated initially by the filing of a criminal complaint. Then there was a preliminary hearing where probable cause.
And what she's doing right now is putting all of this on the record. She's saying, this is how we got here, because most likely he's probably going to appeal this, like I said. And so she's making sure that everything is on the record, all of her decisions, her reasoning for everything, so that anyone reading it can be like, okay, there's no ambiguity here as to what she thinks and why she thinks this way and what she looked at and what the process was.
Cause was found. After that point, there was an information that was filed. And at some point, an amended complaint, perhaps even a second amended complaint, was filed as well, putting you on notice of the charges and the factual basis for those charges, along with the statutes that are alleged to have been violated. I'm not going to explain any further why you can't call the state of Wisconsin in the way that you've subpoenaed them or attempted to subpoena them for the reasons I've already stated. I understand where
that's fair.
You might disagree with the court's ruling, but my ruling stands, and I'm not requiring the plaintiff in this case to serve that subpoena in any way for the defects I've already noted.
May I state for the record?
And I'm also not going to issue a written decision on that. The record speaks for itself.
There you go.
May I state for the record, Your Honor, that I have not even seen a complaint in this matter, and the jurisdiction still has yet to be proven, which is another thing that needs to be challenged. There has not been proven that there's subject matter jurisdiction as of yet. There's no verified proof of it. There's no verified proof of even a claim, especially if I'm not allowed to face my accuser. And I don't understand how you can make that judicial decision, Your Honor, when it's clear discrepancies in the paperwork of this matter. Like I said, I have yet to see jurisdiction be proven. It has not been proven. I have yet to see a complaint. I have not seen that.
The court has provided you with, I believe it was the second amended criminal complaint, along with the information that was provided to you previously and noted on the record. I've already addressed your motion to dismiss previously. I'm not going to revisit that. There's no legal basis requiring me to do that, sir. The plaintiff in this matter has presented witnesses to establish venue. And again, as I've noted previously, it's a criminal case with criminal charges, with a second amended criminal complaint detailing the factual basis upon which these charges are based. We're a notice pleading state. And along with the information, you've been made aware of all of the charges and the penalties you face and the factual basis upon which the state has brought these charges. We are in the middle of trial. Your objections are noted. We will continue today with the jury trial.
For the record, may I respectfully move for interlocutory declaratory appeal on this matter, Your Honor?
Your request is noted for the record. I'm not an appellate court, sir.
For the record, may I move to stay these proceedings until this instant matter is adjudicated by a court of competent jurisdiction?
Your request is denied.
No.
Based on what law or fact, Your Honor?
I've previously addressed the issue, sir.
Yeah. It's because you don't like one ruling that the judge made on excluding a witness or including a witness or excluding a certain piece of evidence, you don't get to stop the entire trial right there and then immediately run to an appeals court on that particular issue. There are only particular kinds of issues that would be either denying well, basically it's the kind of decision that would be is the kind that's like a final decision for that particular case. So, the thing is, he's trying to run a series of arguments with her that just don't fit the arguments for the exclusion of a witness. I mean, he's trying to argue, Sixth Amendment rights, all this kind of stuff, which is fine. But then he's trying to argue it again. Then he's going into jurisdiction. Jurisdiction is not an issue with whether or not he has properly called a witness, right? Or properly tried to call a witness, because we're talking about the fact that he has not done so through the proper process. And the court is allowed to say, look, we have a certain way of doing things. If you're going to call a witness, you have to call a person. You cannot call a ham sandwich. You cannot call the state. You cannot call a dog to the witness stand, because they cannot testify. The only ones that can testify are people. So, it seems like he's trying to go through some strange logical arguments to like wear her down. And I'll say, we're 8.5 minutes into this clip, and I'm already exhausted with the amount of argument that she has had to do, while also being very restrained, while also making sure that his rights are held intact. So, crazy.
So
Based
you're
on
making-
law of the case.
Are you making a judicial determination that I'm not awarded my Sixth Amendment right to face my accuser?
I'm not making any such determination here today. All right.
What law of
I'm
fact?
going to turn to the district attorney's office. Do you have a witness available?
Yes, we're ready to proceed, Your Honor.
All right, our jurors here. All right, the jurors will be brought out, sir.
Your Honor, with all due respect for the record, you're avoiding my questions.
Mr. Brooks, I've addressed the issues that need to be addressed this morning. I've also addressed the same issues probably every day we've been in court. I know you may be dissatisfied with the response that I'm providing to you, but my responses stand.
It's not a dissatisfaction, Your Honor. It's a lack of understanding, which I don't have. I don't even understand the true nature and cause of the charges. And
Mr.
without,
Brooks, you've been made aware of them multiple times.
I do not understand
I
them, is what I'm saying.
Encourage you once again, if you don't understand anything, to seek the advice of an attorney.
Yep.
I cannot give you legal advice.
She cannot. It's
I'm
true.
not asking for that, Your Honor. I'm really asking why are my constitutional rights being prejudiced? It states under the Sixth Amendment that I have the
Sir,
right.
I've already addressed this. Okay.
So he can make a constitutional argument to the judge why she should decide one way or another, but he can't argue to this judge why her decision was unconstitutional. He can do that at the next level. He like at the appellate level, he can say, look, there was this decision that she made, and that was unconstitutional because blah 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 blah. Whatever word vomit reasons that he wants to use. But this is continuing to fight with the judge after she's made a ruling, which we've seen in other cases that have been live streamed at times, that sometimes it, depending on the judge, right? Some judges will work their way back from having their mind made if the attorney kind of keeps going back and keeps going back and keeps going back, and then they'll kind of go back on it. But yeah, crazy. Okay, let me get some super chats and questions here. So we've got Marie Gourand. I'm sorry, I butchered that again. It's actually a very silly pun on merry-go-round. Merry-go-round. I mean, that's awesome. I didn't see that at the time. Once I saw that along with France, I just assumed like, oh, you need to pronounce this with a French accent. But that's cute. I thank you for pointing that out. Jennifer Starks, how does one get a fair trial in this situation? All these jurors are members of the community, and this was national news. I think this is a growing concern with the involvement of social media. I definitely think, I mean, yeah, in any of these high profile cases, right, where it's been splashed across the news and everyone kind of knows about it, or seemingly everyone kind of knows about it, it is a major concern. This is one of the reasons why Harvey Weinstein is going to be going through the jury selection process for a long time in California, is because they have to be extra careful about the fact that who hasn't heard of the Me Too movement? Who hasn't heard of Harvey Weinstein as being one of the prime figures of the that is one of the prime focal points of the Me Too movement? And so in the way that you do that is the jury selection process, because you find people that either don't know anything about the people involved or the things that happened, or you do know people, or you find people that, you know, maybe they do know about this, or they have heard about, you know, what happened, but they don't know enough to have an opinion. And there's you know, people can have their opinions on the jury selection process, because to a certain extent they also are relying on the jurors' honesty in their responses, right? Because if somebody really does feel very biased and they want to get on a particular jury, they could lie in theory. The attorneys could try to sniff that out though, and try to say like, okay, like this person says this, but I don't believe it. I think that they're maybe being an activist juror and trying to get on here. So yeah, but basically, long story short, it's the jury selection process is how you do that. Let's see here. I remember I saw that there was another question in here, and I'm so sorry I missed it. Let's see, I'm trying to find it here. I can't find it. Just because. Thanks so much for the super chat. It says, I work in entity services, and you wouldn't believe how often people try to pull this kind of thing and they don't understand what legal advice is. Yeah. 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 I believe it. I believe it. Toshiro wants to know how do we fix the issue of biased juries in this era of activism? Well, I do think that the pool that people are picked from is probably big enough that the likelihood that someone is going to actually be an activist juror on jury is a lot smaller than people might think. Yeah, realistically, I think it is, but I mean, what else do we do? Jury selection process. You get better at asking better questions. So yeah. Okay. I think that is everything here. Yes. So I think that's probably, should we finish the clip? Let's finish. Or no, I think that's good. I think we're good on this one. All right, let's talk about Danny Masterson next, because there's some interesting reporting coming out on Danny Masterson. Okay. Hey, Laura Cox, I see you in the chat. Thanks for modding. All right. Here we go. Okay. We got some interesting reporting on the Danny Masterson case. Now, this is from Insider through Yahoo. Okay. Actor Danny Masterson's criminal rape trial could shed light on the Church of Scientology's granular level of control over congregants, expert says. So we talked yesterday, right? That was yesterday. So we talked about the role of the Church of Scientology in this particular case. And I I think that that is one of the more interesting aspects of that is what kind of a role, not one of the more interesting, but I mean, yeah, it is an interesting aspect of it is the fact that there is some sort of a role for it to play. And so what kind of prejudices are going to be involved with that? To what extent is it necessary to talk about the Church of Scientology? And because there is some involvement, right? These the women that alleged that he performed these acts were members of the Church of Scientology at the time. And so the Church of Scientology has its own way of dealing with, it's almost like there's their own like pseudo judicial system, basically. So the way that they handle complaints and things like that within the community is different. And it would be relevant for why these women did not come forward earlier than they did for various reasons. And we've seen that coming from the various women who are the alleged victims. Okay. Let's get into it. During a week that will mark the 5-year anniversary of the viral #MeToo movement, the That 70s Show actor, the That 70s Show actor Danny Masterson will stand trial in a criminal rape case that could end up highlighting what accusers and observers describe as the Church of Scientology's specter of control over its congregants. In 2020, Masterson, who was raised a Scientologist and is currently a member of the church, was charged with 3 counts of rape against 3 women who sued him in 2019 following accusations of SA that were made public against him in 2017. By May 2021, Judge Charlene Olmedo, having heard testimony from the accusers, having heard testimony from the accusers, all 3 of whom were former members of the church, ordered Masterson to stand trial. In the criminal complaint, Masterson is accused of sexually assaulting former girlfriend Chrissy Cornell Bixler multiple times between 1996 and 2002, drugging and R-ing another woman twice in 2002 and 2003, and SAing a woman who was too intoxicated to consent within that time frame. Masterson has maintained his innocence. He could face a potential sentence of 45 years to life in prison if convicted. His attorneys did not immediately respond to insiders' request for comment. The Church of Scientology is not a defendant in Masterson's criminal trial, but the women who sued Masterson also accused the church of stalking and harassing them for internally and externally reporting their claims in a separate civil suit. In a statement sent to Insider, a representative for the Church of Scientology previously denied the allegations in the civil suit, calling them obvious, cynical, and self-serving fictions, adding that the church will prevail against those slanderous charges, which is about what I would expect the organization in that particular circumstance to say, whether it's the Church of Scientology or some other organization, right? The Church of Scientology did not comment to Insider on the criminal trial. The judge has said Masterson's case will not be a trial on Scientology. In the lead up to trial, Olmedo has said in the hearing that this is not going to become a trial on Scientology after rejecting attempts from the defense to preclude any mention of the church. Given the nature of the criminal claims, revealed witness lists, and the accuser's history with the organization, an expert on Scientology told Insider that the inner workings of the Church of Scientology will likely come into play during the criminal trial. Rick Allen Ross, the executive director of Cult Education Institute, told Insider that this may be one of the most momentous cases involving the church since senior church officials, including Mary Sue Hubbard, were convicted on federal conspiracy charges in 1978. Those are some big words. For a Scientologist to come forward and say something negative or to go so far as to charge someone who is a celebrity Scientologist with a heinous crime like R-ing is a very, very difficult undertaking. And by the way, the reason why I am censoring that is if I were talking about this in person with you, I would use the actual word. I have no problem with the word. YouTube has a problem with the word. So that is why I don't want to limit the reach of the video just because I have read it out loud. Okay, so it's a very, very difficult undertaking. Ross, who has testified as an expert witness against the church 11 times, including in federal court, told Insider. The nature of the machine that is Scientology, the process of that machine, the net results of the influence and the techniques of that machine are overwhelming, Ross said, adding that the trial may expose how granular the control is. A linked civil suit follows Masterson's criminal trial. The three women claimed that after reporting the alleged sex crimes to police in Los Angeles, they were targeted by Scientology through a wiretapping campaign, and Bixler alleged that individuals working for the Church of Scientology killed her dog. Ugh. I hate to hear that. Hearing that just makes me want to hug Andy right now. I mean, I know that that's harm to animals was one of the accusations, but I can't imagine like the person that goes and does that, assuming that it happened. I'm not going to assume that it happened, right? Because a complaint is allegations. Allegations have to be backed up with evidence. But man, this month the Supreme Court held the California Supreme Court's decision to allow the women to pursue their claims without having to go to Scientology's religious arbitration process. That's not exactly true. This reporting is, and this happens with these kinds of cases. Is I don't know how much. I don't know how much experience the journalist has with law and legal proceedings, but that this month the Supreme Court upheld the California Supreme Court's decision to allow. That's not exactly accurate. Here's what happened. You have the trial court said, yes, I will, Church of Scientology is trying to compel these plaintiffs to arbitration. Yes. Okay. Trial court says, yes, go to arbitration. The plaintiffs in that case said, nope, we don't want to do that. We are going to appeal. So they took it to the California Court of Appeals. The plaintiffs won on that. The California Court of Appeals said, hey, actually, trial court, you're incorrect because of XYZ. Then Church of Scientology said, I don't like that decision. I'm going to take that to the California Supreme Court. Now, when it comes to the California Supreme Court, as opposed to the first appellate level, the first appellate level is a place where the parties have an automatic right to appeal. The state Supreme Court, on the other hand, is not like that. The state Supreme Court has to accept your appeal. You can essentially like apply to have your issue heard by them, but they don't have to. It's essentially, I mean, except for some cases. For the vast majority of cases, they don't have to hear the appeal from the appellate level. And so the California Supreme Court looked at that and said, no, we're not going to take that. So what that means is the decision at the appellate level, where the California Court of Appeals said, actually, no, you don't have to go to arbitration. This is going to be heard in regular court. That was the decision that was standing. Then the Church of Scientology said, well, we've got one more appeal to try. They tried a writ of certiorari to the United States Supreme Court, saying, this is an arbitration issue, but it's also a First Amendment issue because we are a religious organization, and they're treating us unfairly, that in a way that they wouldn't treat a secular organization. And so the United States Supreme Court looked at that and said, no, we are not going to actually take this case. So they rejected it. They didn't make any sort of determination about it. Now, effectively, what is the ultimate result of the United States Supreme Court rejecting that case is, at the end of the day, it goes back to that last decision, the next highest decision that actually was performed, was carried out, was that California Appeals Court decision. So ultimately, yes, that ended up technically like supporting it or reinforcing it, I guess you could say. But the United States Supreme Court didn't make any determination on any of the arguments by the Church of Scientology on this issue at all. So So when I go back and read the sentence, this month, the Supreme Court upheld the California Supreme Court's decision to allow the same woman to pursue their claims without having to go to Scientology's religious arbitration process. Number one, Supreme Court didn't uphold anything. Number two, the California Supreme Court did not make that decision. That was the appellate level. Okay, that's all. Just need to point that out. But everybody gets confused from time to time on these kinds of things, right? So I figure that is probably someone who just got a little bit lost in the process. It happens. They failed to be able to force that, which will have tremendous repercussions, Ross told Insider. Because Scientology created a kind of arbitration as a poison pill to eliminate the probability of litigation from people that have been hurt by Scientology that would want them to sue them for personal injuries. Yeah, I mean, yeah, I had Aaron Smith Levin from Growing Up in Scientology. I had him on the channel where he explained to me a lot of the practices, and he talked about the arbitration procedures in Scientology, and according to him, it sounds like the arbitration process sounds like it's a bit skewed because the person who is an arbitrator is always someone who is in good standing in the Church of Scientology. So where you've got an issue that could be damaging to the Church of Scientology, that's an issue. And especially where the Church of Scientology is one of the defendants, and to have the person that is deciding that be a member of that organization does sound very kangaroo court, assuming that is the case as to who the arbitrator actually ends up being. Okay, explosive witness testimony and documents could define the criminal trial. In the high-stakes trial, Masterson is represented by a legal team of attorneys that includes star attorney Sean Hawley, who is representing the likes of rapper Tory Lanez. I'm sorry, I'm not familiar with this rapper. This is basic bites here. Not familiar with this rapper. I'm sorry, guys. And Los Angeles Dodgers pitcher Trevor Bauer in separate cases. And it doesn't say here, but also Evan Rachel Wood in the Marilyn Manson defamation case. So interesting point that this attorney is basically I'm basically just following Sean Hawley, apparently unwittingly. I didn't realize that's what I was doing. I noticed this just this week. Another accuser separately from the lawsuit who said Masterson SA'd her in 1996 will take the stand. And the prosecution will also be able to reference internal Scientology documents and agreements from the woman. And this week, Deputy Los Angeles District Attorney Reinhold Mueller revealed segments of the prosecution's witness list during jury selection, which included the singer and daughter of Elvis Presley, Lisa Marie Presley. Presley, who left Scientology in 2014, is set to testify after Jane Doe number 1 had claimed in previous hearings that Masterson told her not to reach out to Presley. Okay, for Presley to take the stand for the prosecution against a prominent Scientology celebrity as a former Scientology celebrity, it just has not happened, Ross said. Yeah, but I do think though that it seems, I mean, they may just be getting at the fact that people who leave Scientology tend to be very intimidated by what the Church of Scientology is going to do if they put themselves in a position where they are going to be a threat to the Church of Scientology, it seems. But it is notable that there are quite a few voices that have very loudly decided to speak out against their experiences from when they were in the Church of Scientology. Leah Remini is one of those, which interestingly, it's not in this article, but elsewhere, and in some of the pleadings in this case, Danny Masterson is alleging that this is basically a conspiracy to take him down, and that involved in that conspiracy is Leah Remini, that she has a personal grudge against him, that others have personal grudges against him. But it's going to be interesting to see what kind of witnesses they're able to put on for that. So, all right, Lisa Marie Presley. Although this article doesn't really explain exactly what it is that Lisa Marie Presley is going to be testifying to, other than Jane Doe saying she had claimed before that Masterson had told her not to reach out to Presley. Maybe I'm missing some relationship link or something. Okay, so that's Masterson. Let's do. All right, Kevin Spacey. Okay. Okay. Kevin Spacey's sexual misconduct trial tentatively set to resume next week after defense lawyer tests positive for COVID. So, as I mentioned in the title of this video, there is going to be a delay in the Kevin Spacey case, which everybody's been writing about how quickly this case has been moving. It's been basically going at blitzing speed because it's they started with jury selection super fast, opening statements super fast. They already got 3 witnesses in like the first couple days, and then they've been working with Rapp on the stand for a while, for a few days, but that's to be expected because he's one of the main witnesses, right? He's the accuser here. He's the one that says, I have been victimized by this person. So his testimony is one of the most crucial. Kevin Spacey apparently also plans to take the stand. So that will also be very interesting. And I anticipate that when he takes the stand, he probably will be taking quite a few days as well. What are you doing? Sorry, Mr. Bites is knocking on the other door, the door to the outside. He scared the crap out of me, you guys. I don't know if you could hear that. Okay. What a weirdo. Okay. Okay, but like I said here, it looks like, okay, are you coming in here now? What are you doing? Bye. Okay. All right. Anyway, enough. On with the live stream. All right, let's talk about this because it looks like now everything is coming to a little bit of a halt because one of the attorneys here has come down with COVID. And it's interesting because it's like I have not heard about COVID impacts on these cases for a while, right? Like during many cases in the last couple of years, especially the last like year, now that things have started to move again in a lot of these courthouses. This is like part of the story for a lot of these cases, right? Is like, well, this was filed in 2020 in January, and then all hell broke loose. And so no one was doing anything in person anymore. And everyone's trying to figure out what the heck is going on. And so, somebody getting COVID then delays everything. And so it's interesting that this comes up now at this point. I know that this is in New York. And so New York, I think is one of the places where people are more concerned than in other places. So I wasn't expecting something like this to come up after this much time since the beginning of the pandemic. I don't know if we technically are in a pandemic anymore. Are we? Is that I don't know, but like, can we still call it a pandemic, or do we say that we were in a pandemic? So anyway, but it was interesting to me that this came up. All right, let's get into the article itself. Wrapping up today's proceedings in New York City after a session that started with the ex-House of Cards. I'm sorry, guys. I'm still laughing about him scaring the crap out of me there, and me trying to just like keep everything in and being like, "What's happening?" Okay. All right. Wrapping up today's proceedings in New York City after a session that started with the ex-House of Cards star's lead lawyer sidelined with COVID, federal judge Louis A. Kaplan said the $40 million assault, battery, and intentional infliction of emotional distress case would pick up again on October 17th. However, the caveat is that no one among the vaxxed attorneys on both sides, Spacey, Rapp, the jurors, and court staff, test positive for the virus over the weekend. So no one else can test positive, and the attorney that has COVID can't come back until a certain amount of time. Lawyer Jennifer Keller will not be allowed back in the Manhattan courtroom until Tuesday if she tests negative for COVID over the weekend. With the trial going fully masked Thursday, except for those testifying, Judge Kaplan has ordered that anyone who has been in close proximity to Keller will have to take a COVID test on both Sunday and Tuesday. Based on a 2017 claim by Rapp that Spacey attacked him in 1986, the October 6th starting trial. The October 6th starting trial was always set to have a dark day tomorrow due to a conflict in the judge's schedule. So this could be because of other cases in the judge's docket, that there are other hearings that have to come up. This was something that happened quite a bit in the Depp trial as well, that, you know, for most of the trial, Fridays were off so that this other stuff could happen, or so that the parties in that particular case could work on other motions and get things hashed out. After the dramatic start to Thursday's hearing, the day was primarily filled with testimony and cross-examination of Lisa Rocchio, the expert psychologist hired by Rapp's side. Under questioning from defense lawyer Chase Skolnick over other sexual encounters Rapp had in his youth, Rocchio said that Rapp suffered scattered symptoms consistent with PTSD throughout his life, and then developed full-blown PTSD around 2017 because he was alleged assaulted by Spacey at the age of 14 years old over 30 years ago. The forensic psychologist, who says Rapp suffers from post-traumatic stress disorder, spent much of Thursday on the stand defending her diagnosis to Skolnick. The defense lawyer repeatedly questioned Rocchio's conclusion about Rapp and PTSD. That's to be expected, right? You put an expert on the stand. The expert is friendly to the plaintiff side. The defense has to go hard against an expert. When I say go hard, I mean they have to really put the expert to the test. And this is because the expert is not one of those kinds of witnesses where there's going to be a lot of emotions involved, right? So this is someone who is here as a professional, and they have made some professional conclusions. And so you can test them a bit more strongly because of that, because they're not, some grieving widow or mother or father or, child or something like that. When you've got somebody who is emotionally affected by whatever it is that we're there to address at that trial, then oftentimes you've got to be a little bit more careful. In this particular case, that person would be Rapp, perhaps Spacey also. There might be some emotion involved in that, but Rapp as well would be a witness that we would anticipate would have a lot of emotion. And we did see that in the other articles that we've gone through so far in this case. And so, but the difference there is the position that Spacey's attorneys have is a very hard-lined one. So with that, they kind of have to show that they believe their argument. And because if the attorneys believe that Rapp is lying, the attorneys believe that Rapp is just jealous of Kevin Spacey, if the attorneys believe that Rapp is making this up because, he needs some time in the sun and he wants a limelight and he wants, he's doing it for all the wrong reasons, that basically translates to the attorney saying Rapp is kind of a scumbag. And if the attorney doesn't go hard on Rapp with that argument, then it looks like the attorney is not confident in what they are arguing, meaning that they are kind of like just telling the jury, this is what you should believe, but I don't really believe that. So if they are going to make that kind of a ballsy argument in opening, they kind of have to continue that by being an a-hole to Rapp. And that can be tricky for the jury, right? Because if the jury is somewhat convinced by the plaintiff, then that can backfire, right? It can backfire on Spacey's attorneys. Okay. Where was I? Looking for my spot. Did I read this paragraph yet? Okay, if you know what, whatever, I'll pick it up. Okay, the forensic psychologist who says Rapp suffers from post-traumatic stress disorder spent much of Thursday on the stand defending her diagnosis to Skolnick. The defense lawyer repeatedly questioned, questioned Rocchio's conclusions about Rapp and PTSD. Skolnick questioned whether Rocchio had ever concluded a patient was lying to her about their mental state, and pointing to what he said were inconsistencies in Rapp's responses to the battery of tests she gave him. I mean, and probably the way that may have looked like is something along the lines of okay, so you came to this conclusion that Rapp has PTSD, and the way that you came to this conclusion was because you say that Rapp did this and Rapp did this and Rapp did this, but what if Rapp, instead of doing the second thing, did something different? And so the reason why they would do that is just to say, like, I mean, how would that change your interpretation? Would that change your analysis? Would that change your conclusion? And that can be a challenging place for the expert, because they either have to show that they are not being fully objective by truly looking at everything, and that would change, or they have to show that they are very confident in their opinion despite those other things that they are getting thrown at them. It can be a tough line to walk for the expert. Okay. Rocchio agreed with the attorney when he said that if Mr. Rapp's allegation in the case were untrue, then any trauma he claims to suffer would not be caused by Mr. Spacey. But she maintained that based on her hours of interviews and test screenings of Rapp, many of which are designed to filter out people faking mental illness, that Rapp's PTSD was attributable primarily to the Spacey incident. Yes. Yeah, and I'm wondering what exactly the screenings, the ones that are designed to filter out people faking mental illness, what exactly screenings those were. How rigorous were those? That is something that is going to be that's something that's going to be tested on cross-examination. It doesn't go into the specifics of the questions that were asked, which, I mean, there's already a lot of detail in here. They can't have everything from the trial in here, right? But I am curious. I am curious because there was a whole thing to do about that with Amber Heard and Johnny Depp versus Amber Heard, right? Was this issue of her conclusion that Amber Heard had PTSD. And realistically, when we're talking about PTSD, that is one of those things that is probably more often faked than any other, mental illness or affect, because it's one of those things that's oftentimes a little bit easier to fake. Assuming it was true, she added, a qualification repeated often by Rocchio and a Rapp lawyer, Richard Steigman, under a compromise in wording worked out between the parties and the judge. Spacey himself is still expected to take the stand next week in his own defense. In that vein, and with other defense witnesses anticipated next week, the Spacey legal team will be without their most visible lawyer, Keller, in the courtroom until after she has tested negative twice and her symptoms have abated. And that's interesting here too, right? Because she's the one that did the opening statement. She's the one that before now was cross-examining Rapp. And so it seems like she's been the one that's been designated as the attack dog, so to speak, right? She's the one that has been super aggressive. And so between her and Skolnick, they probably had strategized, I'm going to take this witness, you take that witness, because, I've got this kind of tone, you've got that kind of tone. These kind of things are all part of the strategy. And so I'm wondering if having a different lawyer start cross-examining the plaintiff in this case at a certain point, if that is a different experience for the jury, because you've got a different person coming in. All right, give me 1 second here. To that end, for everyone else, the court clerk could be seen Thursday handing out the familiar blue boxed Binax Now COVID rapid home test kits to Spacey supporters, including his manager, Evan Lowenstein, sitting in the first row. Spacey also raised his hand for a free test kit when the judge asked who wants one. Previously, at 7:49 a.m., the future of Anthony Rapp's $40 million sexual misconduct trial against Kevin Spacey suddenly became very uncertain this morning. Okay, so we're going a little bit out of order. And this is one of the things that's a little bit frustrating with Deadline is they want to have the updates at the top. And so I forgot to scroll down to the bottom to start this article. So this is really what should have been talked about before everything else. That's fine. It's Friday. More minutes after proceedings began in the Manhattan federal courtroom of Judge Louis A. Kaplan, it was revealed that one of the Oscar winner Spacey's key defense lawyers, Jennifer Keller, has COVID. Fellow defense attorney Chase Skolnick told Kaplan that Keller tested positive this morning and has symptoms. The combative lawyer who earlier this week relentlessly tore at Star Trek Discovery actor Rapp's assertions that Spacey fondled and trapped the then 14-year-old back in 1986 on the defendant's bed without his consent at a theater party was not in the courtroom today. When the news was made public, the 63-year-old Spacey immediately put a mask on while seated at the defense table. Ooh. Kaplan, citing courthouse COVID protocols, ruled that all 12 jurors and 10 people in the courtroom, including all of the defense team, their first row of supporters in the gallery, and at least one Rapp lawyer, Richard Steigman, will have to get 2 rounds of tests on Sunday and Tuesday. First focus is on the jury and on trying to save the trial if we can, the judge said sternly. Everybody who was exposed to Keller at close range said they are fully vaxxed. But several people in the courtroom asked for test kits, which will be provided, and everyone who has to get tested now must also be masked. Meantime, the trial that began October 6th will continue, at least provisionally, Judge Kaplan said, before calling for a short break. Testimony then resumed with psychologist Lisa Rocchio telling the court about that Rapp suffers from PTSD, whose onset was delayed and only became full-blown diagnostic PTSD around 2017, triggered by increasingly unavoidable exposure to Spacey via the latter's high public profile, and the New York Times bombshell revelations about Harvey Weinstein, causing Rapp to reflect on his own experiences. And that's something that I think could be suspicious to the jury, to be honest. Because, maybe this is just one way of looking at it, but if they say he kind of had PTSD in the beginning, kind of had PTSD right after all of these events happened and over the years, but 2017 is when everything suddenly got really bad. That could be suspicious timing because that's also a very convenient time to suddenly have PTSD. So could be. And if you have been following this with us so far, at the same time, they also went over all of the movies that Rapp went to see, all of Kevin Spacey's movies. They went through, American Beauty. They went through Seven. They went through, all of these movies that Kevin Spacey has starred in. And he says, yeah, I went to go see those because essentially I'm a professional. I'm an actor. I need to be seeing these movies. I need to be up on what's happening in the film industry, essentially. But my question, if I were cross-examining him, would be like, well, did you have PTSD when you went to go see American Beauty? Did you have PTSD when you went to go see, this movie, when you went to go see that movie? Like, arguably, if you go into a dark theater and you have someone's face on a giant screen in front of you, if that person has attacked you before, that could be triggering, I would think. So to me, considering what we have heard on the stand about those things, I'm going to be honest, you guys. I think that the PTSD thing, I'm not entirely convinced. All right. But let's continue on. Today's wild turn of events comes after Rapp finished his testimony Wednesday. Keller's cross-examination of Rapp lasted nearly 5 hours over 2 days as she repeatedly targeted apparent inconsistencies and vague elements of the actor's recollection of the events and why he took his story to BuzzFeed. I don't know. I mean, yeah, I guess it's factual to say that she repeatedly targeted these inconsistencies. Yeah. But that could also suggest that she's essentially badgering him with it because she can't go over the same topics again and again for a witness, right? Because that is essentially like abusing the witness. That can draw objections. So she this is probably intended to essentially to say that she was pretty aggressive when cross-examining, and that's okay. That's part of the process. Rapp's allegations were among several that made Spacey an early focus of the hashtag #MeToo movement in 2017. The American Beauty and The Usual Suspects Oscar winner and multiple House of Cards Emmy nominee faces trial in the UK for alleged SA, with that case set for June, and he is on the hook for $31 million awarded to House of Cards producers Media Rights Capital because the claims hastened the end of the show and were deemed a breach of his acting and producing agreements. As with all the accusations against him made over the past several years, Spacey denies anything inappropriate ever occurred. Yeah. What do you guys think about this? Do you guys feel the same way as I do about like this PTSD issue? Because I'm not gonna lie, I'm not terribly convinced about that. And that's just one piece of this entire lawsuit. It doesn't mean that he's lying about everything. Or it doesn't mean that I am not going to believe what he's saying for everything else. But let me know what you think in the chat, or if you're watching on replay, let me know what you think in the comments because it's interesting. Let's see here. There was a question in here that I wanted to catch. Where is it? Why do I keep missing these? Give me a second, guys. Oh, here it is. Question from Rosie. Why does it matter if he has PTSD? Wasn't he a kid when it happened? And this is going to damages. Because remember that this is a civil case. So this is about essentially at the end of it, there's going to be a verdict. There's going to be either an award of damages or there's going to be a verdict saying that that he has not done that he's not liable. But if he is liable, there's going to be damages. So if he has PTSD, that's saying that he has been emotionally harmed by the things that Kevin Spacey did. So this goes to helping to prove damages, basically saying that he is entitled to he's entitled to those damages coming from Kevin Spacey's pocket. So let's see here. Iris wants to know, is his PTSD been diagnosed and when did it happen? So it happened. So the alleged incident happened in 1986 and that he suffers from PTSD whose onset was delayed and only became full-blown diagnostic. So it's almost like he had like a tiny bit of PTSD delayed so far after 1986, but that around 2017 it suddenly became full-blown. I am not convinced on this PTSD thing. The more I think about it, the more I'm like, I don't think so. Let's see. All right. Looking at the chat. So random flags, I can see that he has some kind of PTSD. You can also be emotionally affected by something and not have PTSD, though, not have an official, because PTSD is a very, very specific medical diagnosis, right? So you have to fall into like specific criteria in order to have PTSD. You can feel sad about something for a long time. You can carry something with you for a very long time. That doesn't necessarily mean that you have PTSD. And the thing about this kind of a case is yeah, random flag. You're right. The PTSD is a broad term. Absolutely. Maya Johnson, they should get Dr. Shannon Curry. Love her. Agreed. I follow her on Instagram because I love seeing her stuff. I'm like, I would love to meet you. She did a fantastic job in the death trial. But somebody can definitely be emotionally affected, because one of the claims that we're talking about here is intentional infliction of emotional distress, basically meaning that Rapp has to show that Spacey he did something outrageous to Rapp, that was intended to cause him emotional harm, and that it did cause him emotional harm. So he and this outrageousness element is the thing that Spacey did has to be outside the bounds of what anyone would consider to be decent behavior, would be considered to be like what normal society would allow. So yeah, so that's, you can have an IIED case, intentional infliction of emotional distress. You can have a case where somebody isn't alleging PTSD. They can allege those things and just say, I was emotionally affected by this for a long time, and kind of go into the ways in which it emotionally affected you. It could emotionally affect you to such an extent that it disrupted your family life. It disrupted your friendships. It disrupted your work. You ended up losing your job because of it. You were so affected by it. Like that's something that can happen. Somebody can fall into a depression because of, IIED. Those things can happen too, that, you don't necessarily have to go, somebody doesn't have to claim PTSD in order to fulfill those elements and whatnot. April K says, I could see him having PTSD this whole time, but I really have trouble with the idea that it kicked off in 2017 when the cultural zeitgeist changed and he realized that he could make a lot of noise. That's exactly it. It's just, it's very convenient, or it would be very convenient. And that the timing of that fits more into the Spacey side of things than into the Rapp side of things, in my opinion. And D.E. Williams, can you have a trauma response without having PTSD? I mean, granted, I'm not Dr. Curry, right? So like I can give what I know as a layperson on that subject, but yeah, you can, like I said, you can be very emotionally affected by certain events in your life without having PTSD, and that could fit into the elements of IIED. Maya Johnson says, I could see him having PTSD and not really seeing how deeply it affected him until something kicked up all those memories again in 2017. I could see that too. I could potentially see that too. But that's not what's reported here, which doesn't necessarily mean that that's not what the expert witness said, what the forensic psychologist said. Because they may have detailed and said, look, like he was emotionally affected for a very long time. They did go into, he did say in his testimony, Rapp did say that, afterwards he became very promiscuous, very sexually active after that. And that was one of the ways that he was impacted by the experience, because it's almost like, you'll hear sometimes from people in this space, from DV victims, from SA victims, that they'll take a certain route of behaviors that basically, lead them to try to get some sort of emotional fulfillment, which leads to promiscuity sometimes. So I think that that's what they were getting at there. So they can lay breadcrumbs to show how he was emotionally affected, and that PTSD could have happened later. I suppose so, but I am personally, I'm a little bit suspicious by the timing. I'm not going to lie. HDNFT, PTSD often gets tossed around a lot, but I don't know what it is. I need a Dr. Curry course on PTSD. Yeah. Yeah. I think I've had Dr. Honda and Dr. Tracy on my channel for these conversations and stuff before. I wonder if it comes up enough, we could possibly have a conversation about that again with someone. Maya Johnson, well, PTSD is a disorder when the trauma symptoms last longer than 6 months, according to the DSM-V. Okay. Okay. I mean, I will take your word for that. Darrell, if Swan says his whole story sounds sus, if he was straight, I'd put more credence to it, but he's gay. Spacey don't do that to him. I don't think homosexuality should have anything to do with it. Because the plaintiff could be gay or straight and still not want Spacey to advance on them, right? I either way, you can have a sexual advance that is regardless of your own sexual orientation. So, yeah, I disagree with that statement for sure. All right. So that is the end of this article. Well, now we've got a little bit of a conversation about that, but I'll leave that for another time. It's an interesting point, though. I will say that. Oh, Aldwich says, I agree that the description of the onset of PTSD is questionable, but I must say I was very affected when amidst all the discussion of workplace SH in recent years, I remember the trauma I went through. Well, that's a fair point. That's absolutely a fair point. Yeah, I think that definitely is a fair point. So, all right. We are almost at the hour and a half point, and we have gone through everything here. So basically, to wrap all of that up, we've got coming up next week, potentially more Kevin Spacey trial. I don't know. Maybe this COVID thing is going to be delayed a little bit more. We've got one of the attorneys has COVID, and so let's see what happens. Then we've got, it looks like Weinstein is still in jury selection. Masterson also appears to be still in jury selection and pretrial motions and all of that. So that's about where we're at. Maybe next week we'll have more Daryl Brooks. Let me know in the chat if you guys want more Daryl Brooks. If you guys want that level of interesting argument, or if you are watching this in on the replay, then let me know. Let me know in the comments what you would like. So with that, if you guys are still around, then in about a half an hour, I'm going to be on Eric Hunley's channel with a bunch of people in here. And hey guys, just so you know, folks in the chat can disagree with one another. We can absolutely disagree with one another, have different perspectives on things, but we just want to make sure that we are doing things in a way that is respectful of one another. And sometimes people can be offended by a particular perspective, but if someone, is applying argument in a good faith way, we want to keep everything good. Okay, I'm seeing more on Brooks. So, all right, I'm going to take a look. Now, also, as a reminder, Bike Club folks, YouTube membership people, and people that are supporters on Locals and Patreon, everyone will be able to see the same thing. You guys will get a little sneak peek before anybody else on what the next series is going to be that's going to start on Monday. All right. Thank you guys, and have a wonderful, wonderful weekend if I don't see you sooner. All right. See you in the next